Hello, and welcome to Crime in Court. This is the episode. I'm Heather. Sorry, I forgot to say that. And this is episode 7 of Wisconsin versus Zachariah Anderson, Prosecutorial Overreach. So let's see if there was some prosecutorial overreach. We're going to read through the transcript of motions hearing with Honorable Bruce E. Schroeder again. So this is the same judge with the mistrial and the one that we see in the trial that does occur to its full extent. So it took place on January 6th in Kenosha, Wisconsin, and Michael Gravelely was there along with Nicole Moeller and John Birdsall, who are on behalf of the defendant. And this is a motions hearing for dismissal of Prosecutor Gravelely. So they are having an argument in court as to why Gravelely should be removed from the case, and Gravelely is going to argue why he shouldn't be. And we're going to see what, if any, misconduct might have occurred. So here we go. These are the proceedings of this January 6th motion hearing. The court says, state against Zachariah Anderson. The court clerk says there's nobody on Zoom. Judge Schroeder says time set for hearing. This is the case against Zachariah Anderson, and District Attorney Michael Gravelely interjects. State appears by Mike Gravelely of the District Attorney's Office. Ms. Mueller says, good morning, Your Honor. Attorney Nicole Moeller and Attorney John Birdsall appearing together for the defendant, Mr. Zachariah Anderson. And the court says, all right. And I'm told that there was a scheduled appearance by a stepfather of the decedent, and who would be appearing by Zoom, but has not made connection with us yet. The hearing was set for 11:30. It's now 11:52. So, and I have a long scheduled meeting in a few minutes, so I can't wait any longer. This is here on your request for disqualification of the district attorney. Ms. Mueller begins. That is correct, Your Honor. The defense had requested this hearing based on the motion that was filed back in August of 2022 that was docket number blah, blah, blah. Okay. And addendum. Right. All right. The court says, all right. Did you want to say anything further on the subject? Mueller says, yes. I'm assuming the court has read both of these. The court says, I have. Ms. Mueller says, filings. Okay, then. Thank you. Primarily, in addition to what was outlined in both the principal motion and the addendum, the defense wants to stress additional areas of concern as it relates to the appearance of impropriety as opposed by District Attorney Mike Gravelely, primarily resolving around what occurred with Nerita Macias when Attorney Gravelely and Attorney Krasaric had met with her at the residence of Mr. Gutierrez's prior to the trial taking place in March. So, if the court remembers, I had talked about this briefly in the motion, but if the court remembers that the district attorney's office had made assertions on the record that when meeting with Ms. Macias at the residence, that she had informed them that she used Google Maps. That was a big issue that the state had addressed with the court about using Google Maps and how it doesn't take you directly to that area. It takes you to a different building, is what they were saying. However, that assertion by Attorney Gravelely is not supported by the evidence at all. It's the defense's position that that's just a further illustration in addition to what was outlined in the documents and filings of the impropriety committed by the state and to this point. So there's some shadiness going on here by Gravelely. So when Ms. Macias communicated with Rosalio Gutierrez, she had sent him a screenshot, and I have that screenshot with me, Your Honor, if you'd like to see it. But she sent a screenshot to Mr. Gutierrez of the map route. That screenshot was sent to Detective Correa on May 20th, 2020. it's a screenshot of Apple Maps, not Google Maps. Apple Maps, when you input the address, goes to the exact location, and that was made evident by the screenshot that Narina Macias herself took and provided to Rosalio. So this assertion that Ms. Macias used Google Maps is just something that really is not supported by the evidence and was asserted by the state. So the state is trying to say, don't look over here, look over here. I'm not sure where exactly that came from. Okay. So further, law enforcement in this case did a geofence, a geofence, that's spelled GEO fence, as opposed to GO, like an O. You get what I'm saying. Okay. It just made me stop and laugh. All right, so further, law enforcement in this case did a geofence warrant of the area surrounding the residence of Mr. Gutierrez for a large span of time. They retrieved, it wasn't a particularized geofence warrant, meaning they weren't looking for one person's Google information, but rather any Google user that had inserted into that net area during the time of 9 p.m. to, I believe it was 2 a.m. The following day, that would have shown there were several users. There was data that came back from the geofence warrant. Narina Macias is not one of those users, so if Macias had been using Google Maps, her information would have come back in that geofence warrant. It did not. The state knew this. It was just a representation to the court that I'm not sure where it came from. Allegedly, it came from this conversation that was had with Ms. Macias on that day, but the evidence supports the contrary. That Google map was not used by Narina Macias. The date shows that her own assertions show that. But the reason that that's so critical is that they continue it as a pattern of the district attorney purporting information that is not supported by evidence in this case. When we look back to the opening statements of the state made when we went to trial on March 14th, the state talked about Mr. Gutierrez's body being wrapped up in a tarp and taken out that way. So there's no evidence to support that. That's just one of the many examples. And so this is just an out piece that wasn't really outlined in the addendum or the motion to disqualify, but it further supports this appearance of impropriety that the defense and Mr. Anderson specifically really cannot have any faith in what is being portrayed by Attorney Gravelely is something that's one, accurate, or two, something supported by the evidence. This is in addition to the extremely late disclosure of information as illustrated in the addendum as it related to the possible involvement of Michael Campbell. Possible involvement of Michael Campbell. So they had information, the state had information about Michael Campbell being possibly involved, and they didn't turn it over in a timely manner. It relates to the financial documents that were provided the morning of trial of Rosalio Gutierrez when the defense had been asking for that for months prior. So they didn't get it until the morning of trial. Okay, wow. In addition, the diffuser. All of these things that the defense had been asking for weren't disclosed last minute. It's just an ongoing pattern, and at this point, it's just Mr. Anderson cannot surely have any faith that his rights, his due process rights, are going to be really followed or appreciated if Attorney Gravelly continues on this case. Not to mention, perhaps, the biggest elephant in the room being that the defense 100% intends on calling Attorney Gravelly as a witness in the trial of this case. Damn. They weren't bluffing. The defense has already served Attorney Gravelly a subpoena. They weren't bluffing. He's named on our witness list. And given the complete discrepancies between what the evidence shows Ms. Macias's first statement at this new allegation that she wasn't at the real building, wasn't able to see what actually occurred, is something that will 100% needs to be explored by the defense, and Attorney Gravelly is unfortunately the individual who is going to have to provide context to that to the court during the trial. And based on the law cited within the motion, if a prosecutor is a witness, they cannot try the case, and that was something that the state even recognized itself when we had a hearing on the issue of Narina Macias back in March. So I won't really labor anything further, Judge. I feel that that was outlined in the motion and the addendum, the law, everything. I don't need to reiterate everything in the interest of time because I know that you have that meeting and we're starting relatively late. But I believe at this point there's no other option legally other than for Attorney Gravelly to be removed from prosecuting this case. I would open up for any questions and also ask for time to respond to anything that the state might argue, considering they did not file any responses to the filings. The court says, Mr. Gravelly, do you wish to respond? So they asked for him to be removed and he didn't even respond. That's crazy. All right, so Mr. Gravelly, do you wish to respond? Mr. Gravelly says, thank you, Your Honor. So, as I understand, the legal basis that the court is being asked to look at, and the court is being asked to look at the special prosecutor statute, which indicates that a court can, on its own, motion or appoint a special prosecutor under certain circumstances. Of that same statute goes through those. And I'm not going to outline them to the court, but I think the only one that is available by the statute is cited here, would be some assertion of conflict of interest. I don't think any of the others apply. There are 8 listed specifically, such as that the prosecutor was immobilized by illness, that he has been charged with a crime. It has that whole list so they're referring to the statute, different ways you can get a prosecutor removed from a case. I think the conflict of interest, I assume, is the one that they have. They've cited 2 cases. The cases they cite, Retzlaff case, and as a case where the Court of Appeals found that a trial court that did not cause a DA to be removed from a case was upheld, and they were upheld when a prosecutor denied prosecution on a case where the potentially charged individual had contributed $300 to their campaign. Does this guy even hear himself talk? Like, he repeats himself. I don't like reading his sentences because they're hard to, they're not complete thoughts. So you have a case where they say something that appears to be a fairly clear conflict of interest is not sufficient, or at least a judge is supported by finding that that's not a conflict of interest. The Jorgen case stands for a clear proposition, which is that a prosecutor who is a witness to something may not then argue about his or her personal perceptions at that time. What happened in that case is there was an OWI, but also a bail jumping. During that bail jumping case, the assistant DA made observations about, smelled the breath of the individual who was now being charged with the OWI in a different proceeding, and made an argument to a jury at that time that about this other hearing and about their own personal perceptions from that other hearing. And of course, the Court of Appeals found that to be improper argument. You're not allowed, of course, to talk about things that you have personally witnessed that are outside the realm of what the jury has witnessed. So I totally agree with that proposition, but it's not a disqualification case. It's a case about the proper argument, about what the proper argument would be, and of course, the state would not be in a position where it would ever think to argue that. Those are the cases that are cited and taken. The material sort of violations that are talked about are, 1, the following of a notice of expert that an officer, upon hearing from his interview that he had some information about blood spatter and could provide some expertise. He had received some recent training in that. We did a notice of expert, which is within the statutory time deadlines of the prior March trial date. It was 14 days before trial. So that was one of the violations that is described as unethical conduct to ask the court for the extraordinary step to disqualify a prosecutor today. It was not providing a diffuser. This is a physical item that was not in evidence, and I want to be clear about my perception from the state's perspective of that. The defense made multiple requests of this diffuser being produced. They did they? This was never an item in evidence during that period of time. It was a personal piece of property of the defendant we had no possession of. It was still running when you guys got there. That shit is evidence. I'm sorry, but it is. You need to know everything about that to figure out how long he had. Like, you need to know that manufacturer. You need to know. You should have taken that with you. All right, so they had no possession of it. In fact, it was located evidently, and we found out later located at the personal possessions that had been gathered by the mother of the decedent and was out of state. So the mother has it. But the defense in no way told us why it felt it was important, in no way described why that request was something that we should honor, when in fact it was not an item in evidence and certainly not an item under our control. Whatever. Okay. 5 days before trial. Now, remember, the accusation from the defense is that the state has in some way been unethical by filing a notice of expert 14 days before trial, right? Which is within the statutory deadlines. Less than 5 days before trial, the defense files a motion of expert. Their notice of expert is about a diffuser individual who gives a statement in the notice of expert or attached that says, I am an expert on this product. From the photographs that have been shown, I can identify this diffuser and I can talk about its capabilities, how long it would still be steaming. Now, I think this is a snapshot of how the prosecutor myself behaved in this case. I received this notice of expert less than 5 days before the trial. I could have, if really my objective here was to try to adjourn a case which has been alleged in some ways in their pleadings, I could have complained and said, I need an adjournment, or I demand something because of late notice. That never occurred. I could also, within the rules of litigation, because what I discovered when I received this information is that not only did the mother of the decedent have possession of this item in another state, I can't remember where she lived. I think she lives like out on the West Coast, in another state, but she has a receipt that indicated that this expert had the wrong product. Okay, so by the rules of litigation, I could have waited in the weeds. I could have allowed the defense based on what they had to present this expert. I could have walked in with the receipt and cross-examined an expert who then would have found out it was an entirely different product. There is absolutely no rule against that in the litigation here. I could have done that all as information that would be in rebuttal to their expert. I also did not do that, Judge, and that's why I say that's a snapshot of how the state was behaving in this case. Instead, what I did was, before we began this litigation, days before, I personally contacted defense counsel and I informed her not only that it was the wrong item and that their defense expert would be incorrect, so that they did not make those representations in a courtroom to a jury and they have a rebuttal, though destroyed. And I said that I had physical pieces of evidence, and I indicated I had just had, now that I knew what the diffuser's worth was, I had it mailed, and that that would be available at some time when it arrived in the mail. A lot of repetitive words there. Again, we were just days before trial. So given the choice of waiting in the weeds, totally okay based on our rules of litigation, or complaining to the court and trying to get an adjournment, I chose option 3, which was to try to not jeopardize our date and to make sure the defense knew. Now, during the trial, as the court knows, the information regarding this individual who gave a statement saying I was waiting for the decedent outside of his building, right? Prior to this trial, but not just before the trial, not the week before the trial, a significant time before the trial, we had spoken to her. That meeting took place in our office and had a victim witness person present. She gave us a description of what happened. I was not the lone witness, nor were prosecutors the lone witness. When she talked about her vantage point at the building, I merely wanted that pointed out so that we had visual ability to do that. So now he's saying that there's a victim witness person present. He did not say that on the record in the mistrial. So, he says, I was not the lone witness, nor were the prosecutors the lone witness. When she talked about her vantage point at the building, merely wanted that pointed out. I'm sorry, I didn't see that word. When I talked to her about her vantage point, I merely wanted that pointed out so that we had a visual ability to do that. You know, his sentences are so weird to begin with. I thought it was just a sentence, so if I skip a word or whatever. The victim witness person was expected to go along and did not make it to that location. So on her way out of town, we asked her to meet us and to sort of point to where she was. That turned out to happen without a victim witness person. So there's no victim witness because he was caught on the record saying that. So he has to say that. So there was not an extra person, an extra witness present. Certainly that should have never occurred. Certainly that should never occur. I did not remember because it had been some time that there had been the separation where the portion of that discussion had happened without the victim witness person there. Ms. Krusarek, when we were making a report or a record, reminded me of that. I said, I thought they didn't make a report or a record of being there with her. Anyways, Ms. Krusarek reminded him of that, and so I then, at some point, as we were talking about this, I believe I was being asked questions. I then was told that and repeated that at this time. But I had no independent memory of what to be of that, to be clear. And as the court remembers about this element of NM, the court, I know, saw my face in sort of shock when the court started to talk about what it felt might be our obligations prosecuting wise about disclosing this information, because I told the court I consider it a verbal utterance that was not exculpatory and that it was simply a clarification. Do people who know law understand what he's talking about? I surely don't. He's like all roundabout and he's just not making sense to me right now. Is he making sense to you guys? I really feel like no. Okay. Because I told the court I considered it a verbal utterance, and I compared it to the analogy I made to the court is if a witness in a case says, hey, I thought the individual witness had dark skin, and then I interview that person, they say, well, that was the lighting, so it would be a clarification of what that detail was that it was. That's how I calculated it, and I told the court at that time that I would, not only did it not occur to me to provide that additional information to the defense, but if I actually think I would not have done that in any time in my long career. Okay? And the court suggested it was not a discovery violation. This is the record the court made, but the court said best practice that should have been told them. That it should have been told to them. That's what the court told us at the time. Defense asked for a mistrial. The parties talk about that, and then the state finally assented to that and agreed to that with the what our understanding is because that they had given an opening statement where they did not know that information. Yeah, because you had false information or didn't correct the information on record for them. They based a lot of stuff on a key witness. All right, so anyways, so they were at the disadvantage in that fashion. So in an abundance of caution, that was what occurred. Now, this specter of is somebody, a witness, certainly was something. You know what? I'm really hurting. I'm going to put a heating pad on my hip right now. So bear with me 1 minute. I'm going to get this heating pad behind me. All right, sorry. I got SI joint problems, hip problems, all sorts of problems from ankylosing spondylitis. If anybody's curious, ask me a question. I'll tell you all about it. It sucks, and it's painful. It's hard to sit. I'm probably not going to be able to record much more today because of this, and it's just whatever. I'm feeling great. Let's move on. All right, so now the specter of is somebody a witness certainly was something the court talked about with us before this mistrial. And that's been corrected by having Detective Carrera, a main detective in this case, go with NM without prosecutors present. So that's Narita Macias. And he had her show him and made a diagram of exactly where the location is, and so he is a witness to all of those things. And there's nothing in that material that was shared August 5th of 2022, so shared 5 months ago. There's none of that material that in any way is different from anything that I know in this case. So from the state's perspective, we have corrected the concern the court had previously So the defense indicates that though they failed an expert witness notice 5 days before the trial, that our 14-day one is incorrect. That a verbal statement, not exculpatory, it is simply a clarification, is again a moment of misconduct. They are talking about how today Google Maps. So what the state was saying about Google Map at the time was that Ms. Krasaric and I drove to the apartment the same day Ms. Macias went back there to point out the location to us. We used Google Map. That's what we used. We used Google Map. And Ms. Krasaric pointed out, and I then represented to the court, when we used Google Map at that time took us to the wrong building. So the point we were making to the court is a very common app takes you to the wrong building. Now, Ms. Macias has already said now to a detective that she went to the wrong building, so what app got her there is not something that I knew or could represent. I told you about the app that took us to the wrong building, but Ms. Macias is now prepared to testify. A detective has confirmed that she was at the wrong building. Just because she told a detective that doesn't make it so. Just because you brought a detective in to have them walk the premises now without you doesn't make it right. All right, so that is an issue that, if the defense wants to talk about, what app did you use? If they want to question her honesty, I guess they can do that at some point, but we represented that Google Map did that. I don't know what Ms. Macias used. Maybe she talked to us briefly about that at the time. I have no memory of that whatsoever. And so I can tell you there was an exchange between the decedent and Ms. Macias just before she drove down there. She says, I believe it's just before she drove, February 29th, 2022. I'm sorry, 2020. I apologize. February 29th. He went missing on the 17th of May. I don't know what he's talking about. That. All right. I apologize. The decedent shares the location of his apartment in an exchange with an individual. Yeah, I'm still confused by that. Sorry. Okay. So the decedent shares the location of his department of his apartment in an exchange with an individual and says that the GPS doesn't always send to the right place, and this is an exchange that the defense has. Why would the defense has it in their discovery. So again, this is not something that was brand new. On February 29th, 2020, text, I think it means 2022, text, our decedent, no, he is talking about February 2020, text, our decedent was communicating to another individual saying GPS doesn't always send to the right place. We confirmed that to the court by talking about Ms. Kazarick and I personal experience. And Ms. Macias has said that now to a detective. So from the state's perspective, again, just because she told a detective that doesn't make it right, or doesn't make it so, doesn't make it truth. It shows the quality of his litigation and the amount of attention the court should spend on this to hear that the defense believes that our representation, if we use Google in some way, is further dishonesty from us. The diffuser is, I believe, still in the possession of the defense. After we did some testing with the diffuser, we did realize that to the defense. All of the expert witnesses and the diffuser have been in their possession for more than 5 months. By the time this case is tried, it will be almost 7 months that they have had the materials that they are talking about and complaining about not receiving. When you hear complaints about not receiving financial information things, this has been the pattern of litigation from the state's perspective. There have been emails from the defense saying, provide us this. There have been emails from us saying we either don't have it or that's not something that's in our immediate control and it's not something that we are presenting in our case. They have indicated that. And then eventually we have, when we have gone through things, sometimes we have provided those. And when then they have complained at the late hour, things that are not using, things we are not using, we were not trying to push. Why is my brain doing this? It's getting tired. And then they have complained at the late hours about things that we are not using, that we are not trying to put into the case, that they have asked for, have then been presented to them because we were trying to be in compliance with them in some fashion in their many requests. All right, so from the state's perspective, that's the alternative narrative and pattern that the court has. And in the end, this is the very extraordinary remedy the court is being asked. The court saw the state's conduct in this case, so the court is in the best position to make a judgment about whether there was unethical behavior in this case sufficient to go to this extraordinary length in any way, shape, or form. The court also is in a unique position to judge this prosecutor's ethical behavior on the long term. I first practiced before Your Honor in 1989, so the court has decades of experience with this prosecutor in terms of my behavior and in both in this case and over the long run. It is my belief, Judge, that because of my longevity in this county, where's my water? My throat's getting dry. Because of his longevity in this county and the number of many cases I have tried, that Your Honor, as the longest serving judge in the state at this point, that there is no prosecutor in this county's history who has individually tried more trials before this court. So I'm important and I must be right because I tried more trials in front of you, Judge. Other prosecutors can't say the same. They can't say that they've tried. Well, he's also the DA of this county, so. I don't know. I don't know how strong of an argument that is, but anyways. I believe I am the prosecutor who has tried the most cases in front of you, and it is in the dozens that I have tried before this court, and I'm asking the court, and I'm hoping that the court will make a record about whether there has been misconduct by this prosecutor in this case, or whether the court has that concern over my long career. Losing career, yeah. Because I think you are uniquely situated to place on this record whether you have concerns in those regards, and if you do not, then this motion should be dismissed. Thank you. The court says thank you. Ms. Mueller says, if I may briefly respond. The court says you may. This is not about Attorney Gravelly's long history as a prosecutor, what he has or has not done in the past. This is about this particular case and the pattern that the state has exhibited. The state just took apart some of the concerns that the defense outlined and provided an explanation for each one, and then what the defense did. We're not here because of what the defense did or didn't do. This isn't a motion to disqualify the defense counsel. This is a motion to disqualify the state for its continued pattern of providing last-minute notice, last-minute discovery on things that have been asked for months and even years prior to the disclosure. And the addendum really talks about the linchpin of this issue, which was Michael Campbell's report about Michael Campbell's involvement that had been in the possession of the state for months when the supplemental discovery request that was attached to that addendum, which was sent in June of 2021. And that was the last supplemental discovery request of many where the defense continuously asked the state for information regarding Michael Campbell, given that there was information that Rosalio Gutierrez was last seen by him, and the state continuously told us they were not going to give us anything, and they weren't further looking into it. Nothing exists. We're not getting it. Then they have information. Go ahead, Your Honor. The court says, well, finish your thought. Ms. Mueller says, sure. Thank you. Then they have information in its possession. The law is very clear. I outlined it. I can provide the cites again if the court so needs, that they are required to give that to us not only under case law, but under the standards, the ABA standards, which were adopted in State versus Wald. And they withheld it, and they gave it to us. Granted, their trial didn't wind up going in September. The court says, what did they have that they should have given you? Ms. Mueller says, sure. These were the police reports that were attached to the addendum. It was a witness statement regarding the actions of Michael Campbell that were suspect about a rug that was rolled up. The court says, what is it that you asked for? Ms. Mueller says, I asked for, so specifically in the exhibit that was shown on point 4, I had noted that there was evidence that Mr. Gutierrez went to see Michael Campbell. I asked for Michael Campbell's phone records to be produced, and then in emails I asked for any further information. But regardless, the defense has absolutely no obligation under State versus Garsky to seek out this type of information. It is the state's obligation to provide potentially exculpatory information to the defense. And so the court interjects and says, you asked for the phone records. Ms. Mueller says, Michael Campbell. The court says, Michael Campbell. Did the district attorney have those records? Ms. Mueller says, not at that point, and they said no. The court, where is the authority that the district attorney has to acquire information to provide to you? Ms. Mueller says, sure. Under the rules of professional conduct and prosecutorial function, I'm just going to pull it up so I can read it to the court. He says, go ahead. She says, sure. So it's ABA Standard 31.9, which is adopted in State versus Wald, that prosecutors should act with diligence and promptness to investigate, litigate, and dispose of criminal charges consistent with the interest of justice, with due regard for fairness, accuracy, and rights of the defendant. And then it further in that standard, and then in Standard 1.2b requires the prosecutor should seek to protect the innocents, and in doing that should not avoid the pursuit of information or evidence because the prosecutor believes it will damage the prosecution's case or aid the accused. The court says, okay, but I guess what I'm struggling with is that it sounds to me like, well, first of all, there are specific provisions in the law that the district attorney is not obliged to have additional evidence collected or created to serve the defendant's requests, but need only surrender that which she has or he has already in his possession, or that of those who are acquiring evidence of the state, or if it's readily evident that something may have exculpatory value, then he has a greater obligation. But I'm not seeing either of those being. Miss Mueller says, sure, Judge, and I think there might be a misunderstanding of why I was going into the defense's supplemental discovery demand about Michael Campbell. I'm not talking about the phone records, but there had been long discussions between the defense and the prosecutor that predate over a year from when they obtained information about Michael Campbell, about the defense's interest in information regarding Michael Campbell. But regardless, it doesn't even, the court says, no, not regardless, don't want to miss a step here. Hold on one second. Ms. Mueller says, sure, but if there is, the court says, the fact that you're interested in another person, and maybe for good reason, that doesn't make it something that becomes readily apparent to the state that he has to provide it. Ms. Mueller says, sure, but what I was saying, hold on. My boyfriend's home. My dogs are all jumping up and ready to go. Greet them, and they make a bunch of noise. I don't want to blast your ears. All right. So, sorry. Miss Mueller says, sure. What I was saying, regardless, is because that position, even though that they were aware that it wanted it, you're right, it doesn't really matter, let's say. But they had the information and they didn't disclose it again. They had the information for months before they disclosed it, and that was information that was obligated to disclose, and they didn't. Just like they didn't. The court says, why were they obligated to give it to you? Ms. Mueller says, well, it's exculpatory information, Your Honor. The court says, is it evidence that is exculpatory? Ms. Mueller says, yes, it is evidence. The court says, so he has to sit here and try to read your mind to determine what you think is exculpatory, or would it be evident to me, for example? Ms. Mueller says, yes. So what do they have on Michael Campbell? The court says that it is exculpatory. Ms. Mueller says, yes. Mr. Gravelly says the information they're talking about, the court says, no. I'm going to let him interrupt. Mr. Gravelly. Why would you let him interrupt? Okay. So, anyways, Mr. Gravelly, the information they're talking about, they have had for 5 months. So we're talking about something that I believe we're talking about a tip that was given by an individual, and they have had it since August 5th. So they've had it for 5 months, and by trial, they'll have it for 7 months. And we actually went to the further step of when we spoke to Michael Campbell personally. We asked him, would you be willing to give your phone records up without an obligation to do so, and have now provided those phone records to the defense? Those are the steps that are in this pattern of misconduct. So since the last time we actually asked Mr. Campbell, who is a dear friend of the deceased, who is the gentleman of the court, remembers the case, who drove to the defendant's address having never been there before because he was wondering what the heck happened to his missing friend. So from the state's perspective, he is a heroic figure, okay, in this case, not a suspect. And we asked that individual, who we think of as a grieving individual in this case, could we have your phone records like he was somebody who should be charged. So they didn't want to treat him like a criminal by asking for his phone records. And they felt bad. They're calling him a hero, even though he's never been fully investigated. And he said yes, because he wanted this case desperately to go to trial and to go ahead and to get justice, and that information has been provided to the defense months ago. So that's the pattern that you're hearing that here that is for some reason not being brought up in the pattern that is being talked about. Ms. Mueller says, so to this point, and I'm not going to get loud, and I don't think that's necessary, but this was still when the September 12th date was in effect. I don't think it's fair to say that now that we're past the point of September 12th, that anything and everything that the state did do, that perhaps they weren't in compliance with their obligation, we can forget about it. We can forget about it because these are Mr. Anderson's constitutional rights that are at stake. But Judge, to this point, if I may finish, is Mike Campbell, whether he's a heroic figure in the eyes of the state, that is not what the analysis that needs to be looked at here. Was the information exculpatory? Yes. Was providing it approximately 30 days before trial was supposed to start when the state had been in possession of it for almost 8 months. Is that okay? The court says no, that's not the question. Ms. Mueller says, well, that's what the defense believes the question to be. The court says, for me to interfere in the relationship between you and your client, it's out of bounds. There are limited instances in which I would use the limited authority that I have to meddle with your choice. His choice of his attorney, the district attorney represents, was chosen by the people to do this job. That's the other sad part. He's an elected position. This is a big measure for the judge to step into the relationship between the public and their chosen prosecutor and remove him for misconduct when, on the basis of the representations that you're making, and a good example, if my memory serves me right, and it doesn't always, but it seems to me that I recall exactly and did before he started talking, so he didn't feed me the suggestion before he ever started addressing this subject. It was my recollection that the error with respect to Google Media, to the extent, by the way, that I would trust any of the media companies which have been named, but if my recollection was that it was the district attorney who had employed the Google, and whether the fact that he used a Google and then ended up finding out that it gave an incorrect address, which, by the way, I don't know if I mentioned it last time, but I've had personal experience with that. You have been to Sussex. I went up to, why is the judge talking about his own personal experience in here? Blah, 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 blah. Nobody cares. Okay. And I found the Google instructions to get back. Da, 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 da. Oh my God, he's still rambling about... Okay. Pulling over into the gas station. I could identify with what was being talked about. I can't imagine what testimony you say 100% certain he's going to be a witness in this case, which was the most concerning of what you were telling me, was because of the general rule historically has been that the attorney cannot argue his own credibility. That's the ancient rule. I think it has some change both in structure and interpretation, but what in the world could he possibly tell the jury if his knowledge is limited to what this witness said? No, that which is witnessed by another, which does not apparently seem to be in any debate in this case. What does he have to do with that? He could be a witness to be oh my God, my mouth is saying words that are not there. What does he have to do that he could be a witness to that would be relevant to the jury? Ms. Mueller says, sure, I'm going to answer that, and then I have a question for the court in this type of hypothetical sequence. If Ms. Macias gets on the stand and says, no, I wasn't actually in front of the house and GPS took me to the wrong location, that's inconsistent with the evidence. As defense counsel would want, the court interjects, why is that inconsistent with the evidence? Ms. Mueller says, because the evidence that exists is that the map function that she used to take her to the actual apartment building, the time frame that she provides in the text is that she arrived there at 9 o'clock, not 9:38. The court says, the search engine, or whatever you call it, what app she used. Ms. Mueller says there's a screenshot and it's Apple Maps. The court says okay, and Ms. Mueller says, and that takes you to his actual apartment building. The court says, well, how is that inconsistent with the fact that the district attorney said that he used Google? What? That's not what she's arguing. So because he's trying to, the news statement from Narita that she wasn't in front of Mr. Gutierrez's residence, that she was in front of a different one, and if the state is going to be looking to make an argument that she used Google instead, and that it took her to the wrong apartment, then by proxy, they're arguing their own assertions, which they can't do, and would then need to be called upon on the stand to talk about why they're arguing that she could have used Google Maps. But further, Judge, I think that the defense has an absolute right to look and address bias and impeachment evidence with particular witnesses. This witness previously said, the court says, no, you don't have a right to get any witness. Ms. Mueller says, well, I have a right to, and the court says, examine on bias until the witness has said something. Ms. Mueller says, sure. And so if the witness says that her first statement was, and then says a second statement, what her new statement is, which is something different, I would want to tell the jury that it changed after she met with the district attorney's office, and I would want the district attorney's office to testify exactly to what those conversations were and what information was provided and extracted in that meeting where only the DA's office and that witness were present. The court says, do you want to respond? Gosh, here goes Mr. Gravelely again. Yes, she gave a statement saying, I parked in front of the building. We asked her to take us out to the location so we could see what parking space she was in. We went out and she pointed out the parking space and we discovered it was a different building. She doesn't know whether it's the right building or not. How would she know, right? I mean, the address would tell you that it was the right building if you looked at the address and compared on your phone. Oh, 3709 is the right address. I mean, that's how you would know you were at the right building. But I think the prosecution got to her, and now she's not so sure where she was. So how would she know, right? She just took us to the parking space. That's all that happened. She pointed out the parking space. Then we asked the detective to take her out there. He has had a full description as to how she got there. This is a statement given where the detective is actually diagrammed, and he is the one who has documented where she was, and that happened in terms of her process. So there's a witness who is available to talk about that information. There isn't any discussion about where I assume she was going to show us that she had parked in front of the same building. So no one provided her any information of any kind of that sort. She simply took us out there. We didn't know which parking space she was in. She pointed to a parking space and it's a different building. And now a detective will come. He's just reiterating, like he's just repeating himself over and over again. I anticipate she'll show up. She'll be shown a diagram of the parking lot. She'll show and point out, here is where I parked. She'll explain why she parked there. I don't know the answer to that. I don't know why she parked in that location, so I'm not going to be able to be helpful on that. That's where she parked. And it is consistent with what the Google map says, but I don't know if she used Google Map. If they want to impeach her and say she's lying, she has for some reason concocted a wrong location. They can't do that. But there is no additional witness necessary other than the detective, who certainly can be used for impeachment purposes if that's appropriate. Damn, they're playing dirty, man. So Ms. Mueller says, to respond to that, in this second and subsequent meeting with the detectives and Ms. Macias, the detective himself states in the body camera, I am doing this because Attorney Graveley basically wants to follow up on your conversations with him, and every time says, is that what you told Attorney Graveley? Is that what you told Attorney Graveley? So that detective has no personal knowledge to what Ms. Macias told the detective or told Attorney Graveley. Further, if we want to talk about case law, I want to address State versus Hereford. That site is 195 Wisconsin, whatever. And it talks about the exact issue, and it differentiates discovery statutes versus evidentiary statutes when it comes to a statement made by the witness, an out-of-court statement. And in that case, it says that Section 971241, this is on page 1075, requires before a witness other than the defendant testifies written or phonographically recorded statements of the witness, if any, shall be given to the other party in the absence of the jury. Section 906.131 requires that a prior statement made by a witness, in quotes, whether written or not, must be disclosed to opposing counsel only upon opposing counsel's request, which we made. So she asked for it, and they still didn't give it to her. This case then further to talk about why this is important, and it talks about that the purpose of this disclosure from its evidentiary standpoint is to make sure that the statement on which the witness is examined was in fact made and is not misrepresented by counsel in the examination of the witness. So, by not being able to call Attorney Graveley as a witness, we're just relying on that his representations of what occurred, we're just relying on his representations of what occurred on that date is the truth, and I, under no good duties to my client, can just take his word for it, specifically given the pattern in this case, which is we get stuff whenever we get it, regardless of whenever we ask for it. The court says, I don't understand what you're talking about. This freaking judge is an idiot. Sorry, but he is. Ms. Mueller says, what I'm talking about is the case that talks about how it doesn't matter if a statement is written or not, everything that he disclosed. The court says, I agree with that. Ms. Mueller says, because it cannot be the assumption of what an opposing party is presented. So, if I want to then talk about what the opposing party is presenting and being the truth or not, the only way I can do that is to call Attorney Graveley. The court says, what is represented as the truth or not comes in through testimony. What relevant testimony does Mr. Graveley have to offer? Hold on 1 second. Ms. Mueller says the relevant testimony is the conversations that were held between him and Ms. Macias. To this day, I don't know what those were. Mr. Graveley says, so if this was true that, Ms. Mueller says, if I can finish, Mr. Graveley said, I'd like to respond to that because otherwise we get this collective 10 things and no one can respond if that was true. The court says, let her finish, let her finish. Mr. Graveley says, I apologize, okay. The court says, this subsection, go ahead. Ms. Mueller says, thank you. So if he is purporting what was said and what was not said, that's his recollection, which if we're going to take that, the court says he didn't report anything. Ms. Mueller says, well, how can he not remember? It seems awfully convenient that he can't remember the conversations held with a material witness. The court says, I'm talking about at the trial. Ms. Mueller says, sure. The court says, if he walks up here and says, I will offer my own testimony now, and I'll say properly in better legalese, the hell you are, and he's going to go and sit back down. Now, if you're suggesting he's going to call as an impeachment witness for the person we're talking about, that's a different issue. But as of this point, I don't know what reason I would let Mr. Graveley talk his way onto the stand. In the mistrial paper or in document that we were reading, he was saying that one or both of them would be called to the stand and kicked off the case. And now he's saying it's not that far. He's not coming to the stand at all. Said, I don't know what reason I would let Mr. Gravelly talk his way onto the witness stand. And I'm not going to assume that the testimony of this witness is going to be incompatible with what anything Mr. Gravelly has said. And if he feels that she's inaccurate in what she says, they'll be able to cross-examine her. But then we do get into a thorny area here. I'll admit that. Ms. Mueller says so. And I think back to looking at Hereford, one of the issues that the court projected and foresaw was that a lot of the times we can't as such as we want to sit here and say exactly to what she's going to testify to. Like, we can't. And we don't know how that testimony is going to come in. And to the point that you just made it, it's going to, there could be an issue where she says, I wish these people would just finish their damn thoughts instead of going all over in sentences. I know it's harder to read, like, people talking rather than a scripted out something or written out, but it's annoying because it's like, where are these people going in their thoughts? And to this point that you just made, there could be an issue where she says there is what was said by him, and if he believes that to be wrong and believes that to be wrong, then we're at a situation where Attorney Gravelly, the defense, would call the state and we would be in another mistrial. The court says, well, you'd call Mr. Gravelly, Ms. Mueller says. And if he's prosecuting the state, what do we do when we have to call him as the witness? And the court says, just tell him he's not. Ms. Mueller says, in the middle of a trial, the court says, I could do that, and Ms. Kasarik can continue the case on behalf of the state if that's their desire. He could employ someone voluntarily at this point to be standby who is not under his discretion or under his direct supervision if he wanted to. I'm not saying he needs to, but for me to try to anticipate everything that could possibly happen and not only do that, but do it in the worst possible, as the people who are critical of the weather forecasters sometimes will say Channel 4 News Weather has correctly predicted 18 of the last 4 tornadoes, I'm not going to anticipate 18 horrible things happening during this trial. It's wise. I'm glad that you've introduced these possible issues so that I'm ready to pounce if there's an issue. But for me to conclude, he needs a flexible pen. He's not allowed to have a pen. That's not a rule. That's for you, sir. That's for everybody that comes in here. Okay, good. Somebody got a pen. I don't know. All right, it's good that these issues are here, so I'm ready to pounce if there's a problem, but I'm not going to anticipate everything that could go. I'll digress and spout off about something else. That's how adjournments get into the criminal court system, or all court systems, is when people come in and say, I've got a trial date, they're not going to try any of those cases, and they know it. They're not lying, and they do it because they really do have the cases scheduled. Is the court still rambling on? Oh my God. But when I ask them, well, how many cases did you try last year too? And say, but you just ruled out the next 52 weeks because you're booked, and I'm going to do that. I do not anticipate that there is going to be this issue that you're concerned about occurring, and I continue to believe that the statements that were made when I declared the mistrial were that Mr. Gravelly had used that as sort of a search instrument, which in my own experience was unreliable, and that's irrelevant that he did that. So I cut you off. Ms. Mueller says, no, that's fine. I think we were in the midst of discussing that issue. I didn't have anything further on that point. I'd have other things to say, given I can obviously see where the court is going in ruling in the motion, but I know. And then the court says, that's about it. That could use some polish for someone to say that to a judge. If you want to, you're welcome to think it. but it's not usually a good presentation in a court. Well, Ms. Mueller says, well, I'm just saying that I don't have anything further, and I have other further things to ask of the court that are not related to technically what was just argued. I know that the state had something it wanted to say, but the court says, that's all right. You're keeping me from my meeting. Go ahead. That's rude. Ms. Mueller says, if the court is going to deny the defense's motion, and there are other things that I would request, one, that being, I would want a colloquy held with the state prior to the trial, basically a conversation with the state prior to the trial, starting about whether it has disclosed everything in its possession that it's required to the defense, and if not, why at this point. And I'd also request and I can write this in a formal motion in limine and proposed order, if the court would so prefer, that the state cannot in its opening refer to Google Maps or anything of that sort, given that it's not going to be relevant. If that's his assertion now, is that wasn't said by Ms. Macias, that not be able to come in. Then I would for those two things. The court says, on the issue, the comments that I've made, which were my comments, not his, I told you what he didn't make any representation as to whether he wants to go into Google Maps or not. I made the statement that my recollection was that he limited what he said last time to his experience with Google Map. Ms. Mueller responds, he said earlier to the court that it was his recollection that he just used it, and it was not Ms. Macias. He said that earlier. He did say that earlier today. Mr. Gravelly says, I don't know what Ms. Macias, so please stop misrepresenting The court says, the consistent recollection that I have, and I could be wrong, is that the only statement he made about Google Maps was that he had relied on it to his detriment. And Ms. Mueller says, sure. I love her, sure. Like, sure, I get that, but I'm saying this. I'm saying that that's what the court is saying. It's recollection. The state has said today on the record just now and earlier that it does not know what she used. So the defense is asking that if the court is going to deny the motion, that an order be put in place that Attorney Gravelly cannot interject any theories about Google Maps being used, and that Google Maps or something other than what the evidence purports, which is Apple Maps, took her to the wrong location. Court says, I am going to tell him what I would tell any lawyer who is going to make an argument to the jury. If you make a statement in opening statement, you should be able to prove it. If you don't have the proof, don't make the statement, because one way or another it will get shoved down your throat, either by the court if necessary, or more likely by the other side. Ms. Mueller says, sure, and I guess where the defense is coming from in that request isn't just with the rules surrounding that's permissible in an opening statement, but more so that if he opens up the door about Google Maps being used, then he's making himself a witness again. And the court responds, it depends on what he says. There is such a universe of things that he could conceivably say. All right, anything else? Ms. Mueller says no, and the court says thank you. Gravelly says I have nothing else. The defendant says, hold on a second, Judge. Ms. Mueller says, Judge, there is nothing further from the defense. And the court says, thank you. The motion is denied. So the motion to remove Gravelly is denied. What do you guys think of his conduct in this case? Do you think he was holding information? Do you think that he had any influence on changing Narita's testimony or statement? I think it's very possible. It's very possible. And it's unfortunate that there are prosecutors out there like this that can go and they have so much power over people. Prosecutors have so much power. And They use it to the full extent. All the power behind them, the law behind them, everything. Like they use it, all the resources that they have. So it's tough to compare to that, especially when you don't have the means, or you have a smaller defense team that just doesn't have the time to go over everything. So it's tough. So we're going to go into, I believe our next episode might be the Denny motion. I can't totally remember. I think the next episode is going to be about the Denny motion, because that goes next in like chronological order of how things happen. So I think we're going to do that and talk about Michael Campbell and his involvement in this, because as Nicole Moeller said, he has some kind of involvement in this from the discovery that she received. That's what she said. So we'll take a look at that in the next episode. Be sure to hit the like button and subscribe and comment on your way out. Thank you so much for being here. I appreciate your views and your likes, and I'll see you next time.